Hi, all. Welcome to Yoke's YouTube channel. Thanks for tuning in. I hope you're all having a great day. And today we'll be discussing about can IRCC's decision, like a refusal decision, can it be challenged? We do get questions regarding that. So we thought that we'd discuss with you what are the options and um, things like that. So in Canada, a judicial review is a process where a court examines a decision which has been already made by administrative bodies. Like, so we are discussing regarding immigration cases, so IRCC. So a court can examine decisions that has been already made by IRCC to ensure that it was fair, lawful, and reasonable. So basically, it is not just your typical appeal where a high court re examines the merits of the case, but mainly what they are looking at is if the review of whether the IRCC acted within its legal authority and followed proper procedures. And in terms of Immigration Canada's IRCC, decisions related to a wide range of applications, such as study permit applications, work permit applications, visitor visas, and PR applications. Yes, and the Federal Court of Canada will review the decision to determine if it was reasonably, and which means it must be internally coherent, based on a rational chain of analysis and justified by the fact of law. That's what the court basically looks at. They're not looking at the situation. They are basically, the court will look at, was the decision made fairly? That's what the case really does. And in Canada, a judicial review can be applied for any final decision made by IRCC that is considered irreasonable, unreasonable, or incorrect. So, what we were planning of is basically we are planning to begin a new series with real life cases, case laws where decisions has been made by the court from IRCC and which IRCC has refused the application. So basically, what the purpose is, these case laws where cases somebody has received refusal from IRCC, they were really positive that they will not get this, and they do believe that IRCC did not handle their case reasonably or incorrectly. They have, IRCC has looked at it, so they do have the right to go to judicial review. So we will be looking at real life cases of how the case was presented and what are the scenarios that were taken into account when the Federal Court of Canada came up with the final verdict on that. So basically, what is the purpose of a judicial review is to ensure that IRCC is acting with the bounds of the laws and are not abusing their powers. Because so many times we hear that, hey, IRCC is very biased to me, or this way, or these things are. So this judicial review is a point where the court does look at the fact that were they really using up their powers, or did they act lawfully. So judicial review is for that, and the focus of judicial review is basically the court assesses whether IRCC had the power to make the decision and if they followed correct procedures and if their decision was reasonable in the light of the evidence. So basically, that is what is being given highlight on by focusing on judicial reviews. And it is not a rehearing in the judicial review. So whatever was given as your evidence in your application when you submit it to IRCC, what judicial review, they are not basically looking at, right from the beginning if they assess the application properly. They're basically, it is not a chance to argue the facts of the case or to seek damages. The court is not deciding whether they would have made the same decision. They are focused on the legality and fairness of the procedure. So that is what it is. How fair IRCC was. That's what um, the judicial review is meant to do, and it is available to challenge government actions. So, judicial review is a tool for people to challenge decisions made by various levels of governments, including those related to immigration or be it any kind of industry. And that's what judicial reviews are for. And they are different from an appeal, as I stated earlier. Appeals, they deal with decisions made by courts, whereas the one that I mentioned, judicial review, focuses on decisions made by administrative bodies like IRCC, Immigration Canada. So, what is the Supreme Court of Canada has established that the reasonableness standard should be used in most judicial review cases, meaning the court will consider whether the decision was reasonable within the context of the IRCC's work and the relevant law. So, as I restate again, that they mainly look at the fairness and how reasonable or was the decision made correctly. So that is what, to give you a brief outline of what is judicial review. And specific examples of IRCC's decision that can be judicially reviewed are, say, if you get a study permit refusal, yes, that can, we can go with that to the federal court to receive, to do a judicial review. The same with work permit refusals, visitor visa refusals, express entry applications, sponsorships, which are done sponsorship outside Canada, and there are other final decisions that can also be gone to the federal court to for a judicial review, and also to say that judicial reviews can only be done by a lawyer. A lawyer has to do the paperwork to go to the court and present your case to for the judicial review to the federal court. It cannot be done by an RCIC, so that is a point to be noted, and that's what we are planning to be doing. So we will be doing looking at real life situations where a person did receive IRCC's refusal and they did go to a federal court to do a judicial review, and what was the outcome. In some cases, yes, they do still receive a negative decision. However, there are cases where there are positive decisions. So this will give you a better idea of, if you are in this situation, what what is the worst case that could happen. So stay tuned for that. We are planning to begin that series next week, and thanks for tuning in.